Greetings everybody, I am सैयद मुसाब रहीम हाशमी एडवोकेट। और हमारे साथ आज है और एक साथी, उनकी तरफ मैं कैमरा पलटाऊंगा। तो आज हम लोग जो है ये जूम मीटिंग रखे हैं, 45 मिनट्स तक चलेंगी। इसमें जो है वकालत के बारे में कुछ चीज़ें डिस्कस किए जाएंगी और लॉ स्टूडेंट्स और एडवोकेट सवाल जवाब भी कर सकते हैं। और फ्यू मिनट्स में और भी लोग ऐड होंगे। तो वकालत का बेसिक चीज ये है कि रिप्रेजेंट करना, क्लाइंट्स को जो है कानून और एविडेंस किस तरीके से पेश करना कोर्ट में, उतना डिटेल मालूमात आम आदमी को नहीं रहते। तो इसीलिए आम आदमी के बिहाफ पे एक एडवोकेट अपॉइंट करके वो एडवोकेट कोर्ट में जाके ये फैक्ट्स हैं, वो फैक्ट्स हैं, ये फैक्ट्स के बेसिस पे आप फैसला करिए बोल के जो है वो करते, डिस्कस करते, तो फिर उसके बाद आपको फैसला मिलता। somebody is trying to join, मैं एक सेकेंड साइलेंट हो जाता हूँ, प्लीज डोंट माइंड। तो अभी मैं हमारे दूसरे साथी की तरफ से चलता हूँ।
Good evening, all of you. Yeah, today we are going to discuss about the wakalat. What is wakalat? How to fill the wakalat? What are the advantages of filing the wakalat, and who can file the wakalat? Actually, the person who is on record can file the wakalat. The person has to become the member of the Bar Council of India, Telangana first. Then it is converted to the Bar Council of India. The certificate is issued by the AIB. AIB means All India Bar Examination. Once they clear the AIB, All India Bar Examination, the Bar Council of India will issue a certificate. It's a permanent certificate. Nowadays, we have to renew it every 5 years. We have to submit the wakalat we have filed in the courts. At least we have to file 5 wakalats in a year, per year, to become the permanent member. And it is an profession, it is a noble profession. Everybody want to enter into this profession, and it is regulated by the Bar Council of India in India. And we have to do a 5 years LLB or 3-year LLB to continue as an advocate in India. And we are having lot of opportunities, job opportunities in India also. Like we can become the independent practitioner, we can join the corporate offices, we can become the public prosecutor, we can become the judge also. There are some new members are also joining the sessions. Yeah, we welcome all to join this session. Yeah, today we are going to discuss about the wakalat and what is the importance of the wakalat. Actually, the layman don't have any knowledge about the advocacy, so they are unaware about the laws, prevailing laws of the land. So they hire the advocate to represent him, and advocate is the authorized person to represent on behalf of the client in the court. Like we can represent the client in all over the courts except the Supreme Court of India, until unless we clear the advocate on record exam. The advocate on record exam will be conducted by the Supreme Court of India. We have to the eligibility to become an advocate on record is like that. We have to be a practitioner for at least 5 years, 4 years in the High Court, and 1 year in the as an intern and junior in the office of Supreme Court advocate on record advocate. And we have to hire one office in and around 10 miles. It is around 16 kilometers from the of Supreme Court of India, and we should have one clerk, registered clerk. Then we will be eligible to write an exam to become an advocate on record. Friends, there are two type of advocates. One is advocate and one is designated senior advocates as per the Bar Council of India. So most of the people don't know who is the senior advocate. Senior advocates are the person who is having a good practice in High Court. High Courts and Supreme Court of India will designate the advocates as a senior advocate. To become a senior advocate, the person has at least 10 years of experience as an advocate and practicing in High Court or Supreme Court of India. So once they have to file an application before the High Court or Supreme Court of India to become an senior designated advocate. Then they will check all your eligibility, like what all the cases you have done in the High Court and Supreme Court of India. They will scrutinize and they will call you for the interview. The benefits and disadvantages of becoming the advocate on senior advocate. Like the senior advocate is the person who is having an opportunity to be here first. So suppose as an advocate, the petitioner will start his argument. But if senior advocate is is arguing the matter, whether he is a petitioner or respondent, but he will start first. And he can enter in any case without any wakalat. He doesn't require any wakalat to enter as an advocate in any courtroom, and he doesn't require any wakalat. He can go and argue in any case which is instructed by his client. If client want the senior advocate to represent on behalf of him, he can go and he can argue the matter. No need of filing any wakalat. And the disadvantages is that he cannot file wakalat in any court. He should depend on his junior advocates to file an wakalat. Only junior advocates or normal advocates can file the wakalat, and the senior advocate can represent on behalf of him. So you have seen lot of senior advocates, they are not filing the wakalat, but they are representing the cases. The person who is having the senior designation is having some privilege in the bar. Like they get the designated places like a separate bar association rooms are there. They will there might be a chances to become a high court judge also for the senior advocates. So Musab Hasmi will discuss further regarding this senior advocates. I am giving over to the Musab Hashmi.
Greetings, everybody. How are you once again? Thanks for taking out the time and being with us. And our friend advocate has also given his time. He was going from Woxen University to his home. He's a PhD scholar in law. He has completed LLM from Sultan Ulum. So about advocacy, recently I have seen in the newspaper that LawSet exam is being conducted in 3 batches. So there is so much of demand. People are wanting to become advocates. So this is a field which is increasing in demand. More and more students want to do it. So we wanted to bring about awareness about this field in the common public, as brother was saying. So this is a 3 years course of LLB or 5 years course. If you have already done a graduation, then it's a 3 years course. Then you will have to enroll in the bar council by showing your provisional pass certificate. And then within a period of 2 years, you have to clear your bar exam, All India bar exam. Usually it is being conducted 2 times in every year. And until now, it is an open book examination. You can carry the bare acts. You can carry Constitution, IPC, CRPC, and other BEAR acts, and you can refer those books and you can write the exam. It's a good field, but in the beginning, that much income may or may not be there. In the field of corporate law, or if you are working in somebody's office or in the LPO industry, then from the day one you will be having good income, or in the field of teaching as well. But once you get into litigation, in the beginning, you will be an unknown advocate in the market. People will not know you. They don't know your track record. They don't know how many cases you have won. They don't know in how many years you are doing the winning of the case. So being unknown advocate or not so popular advocate in the beginning of your profession, it may be challenging little bit. But once you have acquired a good name and reputation that this advocate is good, and the success rate is nice and the cases are getting solved quickly, in that scenario, people will come to you, and once the people begin coming to you with cases, then sky is the limit for the workload and the income. So these are the things, and in the society, generally people watch movies and they think that in front of the judges you are supposed to scream at the top of your voice, and sometimes a rough way of speaking is shown in the movies and serials. But it's not like that. You have to be very polite. You have to be very soft spoken when speaking to the judges. You have to begin by saying, "My lordship," or "Your Honor, can I say something?" Then he says yes. And then you continue with your argument. You give the proofs. You request him to come to page number so and so. He comes to the same page number. You read out the things, and then he listens. And then the chance is given to the PP and GP, public prosecutor, and government pleader. He represents his case if it is the High Court. In the lower court, the other party, the respondents or the petitioners, they will respond to your arguments, and then either a decision may be given or another date is given, and then the case continues that way. And also it's a lot of teamwork, like for drafting and filing, and then for taking all the dates. All one single advocate cannot do everything. It's always good to have a team. People who are good in writing and typing, they can go for drafting. People who are good in filing, they can go for filing of the cases. And then those who are good in arguing, they can argue. And then a team of research people has to be there in the back end who search on their computer or in the books that what are the relevant case laws, what are the old precedents which are in favor of your thing. So accordingly, things happen. I would like to give this to my brother, and usually there is a doubt in people that civil law, LLB, criminal law, and high court law, which LLB is there, or is it the same LLB for all the advocates?
Yeah, actually, first of all, you have to complete your LLB. LLB means you are having an certificate to become an advocate. For once you become an advocate, by doing the litigation, or you have to select your own field of interest, in which field you are interested. Like some people want to become an criminal advocate. They do in criminal advocacy also. There are a lot of scopes. Like nowadays we are seeing the lot of white collar crimes, cyber crime and all. Earlier there was only the criminal law, but there is a much demand for the advocates who is having the knowledge about the cyber crime nowadays. And some people can go for the IPRs also in the corporate law. Some people can go in the contracts, joining as a legal team of the corporate companies. And some of the people can join the government organization, and some people may go for the what you call the research scholars in the High Court and Supreme Court. And most of the people refer to go for the civil cases. In the civil also, there are a lot of branches are there. Like we are having the drug control, rent control courts. There are a lot of tribunals like consumer forum is there. We are having the Lok Ayukta. We are having labor courts. We are having negotiable instrument courts. There are a lot of courts for the administrative tribunal is there. Work tribunal is there. There are different codes are there, and you are eligible once you complete your LLB. You are eligible to become an advocate. Once you pass the exam of AIB, it become a permanent like license for you to practice in all over the India. Not even in one state, you can practice in all over India. Like most of the people go in different fields. Some people are interested in the human rights. Human rights is very good field, and you will see lot of people who are underprivileged and not able to hire the advocates, and most of the people are suppressed by the public authorities, and sometimes we have seen the custodial death, torture by the police. Lot of cases are there, and you can file the cases before the human rights forum also. We call this as human rights commission. There are three type of human rights also. We are having the at the district level, state level, and the national level. And most of the people go for the labor courts also. Labor court is also a challenging job, and it's very interesting. We are because you are fighting for the rights of the workmen. What type of working hours are there? What compensation they should get? What all the benefits they have to get? You are fighting for their, like some accident is happen. There are sometimes you are petitioner, or sometimes you are respondent, because every times one party is wrong and one party is on the faith. So you have to choose your profession wisely. And I want to tell you one thing, that if anybody comes to you taking a brief like case, you should not say that I am not going to take this case, because as per the Advocate Act 1961, you have to accept all the type of cases, whether it is a civil case, whether it's a criminal case, whether it's a labor case, whatever it may be. You have to represent on behalf of the client. You cannot say that I don't have any knowledge, like that. You cannot say, because it's your responsibility to protect your client. So you have to fight for the rights of your client, and it's your responsibility. I want to tell you that everybody should join the advocacy profession with enthusiastic and energetic way, and they should have the knowledge of both corporate and the litigation also. So I will give the cam to Musab Hashmi.
Thank you, brother. Greetings once again. So now we will discuss about the steps to be taken when doing a case or handling a case. Second. Mm, So whenever a client comes to you, so these are the things which happen. They describe various things, that this has happened and this has happened. Uh, the story, the description which the client gives you, you will have to note it down, and then you have to condense it into few sections, maybe 1, 2, 3 sections. And then after you condense it into sections, you have to go for drafting. Uh, in drafting of the case, you write, you begin with the court's name and then parties' names, and then you have the address for service, your address, and the client's address, and the sequence of events which have happened. If it is a counter, the counter sequence of the things which have happened, followed by the docket, and again the address, the court name, and the details. Then after the drafting is done, you go for filing. In each court, the filing system is different. Like in the High Court, you have a new filing section which is separate building, which is inside the compound of the High Court. And in the trial courts, usually you have the Nazarat section, the filing section, which is either attached to the court hall, or the door of it is very nearby or just opposite to that. It's at a walkable distance from the court hall. So each court hall in the trial court has its own filing section, and then in the tribunals, you may have a table or a desk on which you go and file your cases. So filing is different in different courts, and then after filing, it will come for argument. The first date of argument is very crucial, in which you will have a good impact on the GP, the PP, the other advocate, and also you may have some impact on the judge as well. You'll give your facts, or if it is a trial court, then it may take a little bit longer time. After some time, it comes on the bench, and then arguments are done, chief examination, cross examination, they also call it examination in chief or chief examination, then cross examination happens. Then at a later stage, judgment is given. In the High Court, when you argue, either the judge can listen to your argument and give the judgment then and there, or he may say that let's give a chance to the PP, GP, or the other advocate to represent their version of the facts or the counter. And then it will take more time. Again, the date will come. You may have to mention it. If the date is not coming, then you may have to mention it at 10:30 or sometimes in the lunchtime, so that the next nearby date is given. And then for preponement also, you can make a paper and submit requesting for preponement of the date if there is a valid reason why do you want it to be preponed. And then after hearing both the arguments, a decision is given. Then again, your clerk or you yourself will have to go to the filing section and request for the order. And that order you have to take it and bring it to your office. And then the client will take from your office. These are the general steps which are followed in doing a case. You either if you are a one-man office, all the things you can do, which is not very practical. It's good to have a team. Those people who are good in each activity, they can handle those things. That way you can cover more cases. So these are the things. Day before yesterday, we were discussing about the rights of arrested persons. If you want, you can add few things about. Now we will cover a little bit of criminal code.
Yeah, surely, surely, I will.
Then-
Let's discuss. Actually, it's a crucial time when the police come on your door. So suppose if police comes to your door and ask your family members or some like you regarding the accusation in some criminal cases, then it's a very, very, very crucial time. So what we need to do at that time? We have to check his identity, whether it's a police personnel who is on your doorstep or not. And you have to go along with the accused to the police station, whether they are taking to the police station, whether they are taking to some other department, and there are some of the rights for the accused. That is in the custody of the police, they can ask to meet his advocate. The police should provide the clean water, toilet facilities, food, medicines, and all. Recently, we have seen that in the case of Arvind Kejriwal, the medicine is not provided. Like he is a diabetic person, but police officials and the investigation agencies has not provided any medicine. Due to that, it affects it adverse effect on the health of the Arvind Kejriwal. So the Supreme Court has taken the suo motu action and asked the public prosecutor why the facilities have not been provided. Actually, it has been written in the what you call international human rights. Like it's all the countries is having the similar what you called human rights system. It is similar for all the it's an what you called it is similar in all the countries. Every human is having a right to live dignified life, and until and unless the accusation is not proved, you are a innocent. Until unless the court has not convicted you, you are an innocent person. So nobody can say that you are a convicted person or you did a crime until unless it is not proved you are innocent. So every person who is having an allegation have the equal rights, same like as an other person. It has been written in the Article 21 of the Constitution of India also. So nobody can uh, what you called arrest you without the proper cognizance of the case. If it is a non-cognizable offense, the police should not arrest you, and they cannot detain you for more than 24 hours. If it's an cognizable offense, they will definitely book a case. There are some difference between the cognizable and non-cognizable. The time is not permitting me to explain you in the details. So we will make the one session on the what is cognizable and non-cognizable offense, and what is a bailable and non-bailable offense, what is compoundable and non-compoundable offense. These are some of the differentiate between the cognizable and non-cognizable, bailable and non-bailable, and what is compoundable and non-compoundable. uh, I, wa- I will tell you in the what you call the brief regarding this things in the later session. Uh, in this session, I'm going to discuss regarding what is bailable and what is non-bailable offense. Bailable offense means the police is having an authority to give you bail in the police station itself. It is below 3 years. The crimes which is below 3 years are come under the bailable offense, and police is having the right to give you the bail, and you have to deposit the sureties required by the police personnel. And the non-bailable offense are the offenses in which magistrate is having the power to grant the bail. Police officials don't have any authority to grant a bail in the non-cognizable or in this
Unbelievable.
non-bailable offense. So only 10 minutes are left for the sessions. I will give over the cam to Musab Hashmi. He will discuss regarding the bailable, non-bailable, compoundable and non-compoundable offenses.
Yeah, that also we will do, but because of the time issue, I will give you few tools which are useful for advocates. Like if you say about softwares and the things which can be in your phone, these are the things which must be there in the advocates and law students' phones. They are Adobe Scanner, PDF scanner. Usually the clients, when they send papers, they are sending photographs. And those photographs, when you print it out and submit in the honorable courts, sometimes they are not accepting. And even if they accept, sometimes the readability is very difficult. And also, if it is a photo and you take a printout of that, it gives gray shade on the sides. So have a Adobe PDF scanner on your phone to send and receive documents between the client and yourself, and between advocates and the team. And then you must have a Word document in your phone. Then you must have Google Lens. With Google Lens, there are various benefits, like you can go for translation. Then you can copy the text written in a document and paste it in a Word document. Then you and your clients must have an open camera It's an app which is similar to your camera app. You can download it and specify it to include the date, time, and location, which can be used by your clients mainly. Then the apps which you must have. Yeah, and for arguing online, Cisco WebEx was being used in the High Court, but now they have done their own app known as vConsole. So you must have a vConsole also. Then there is a Telangana State High Court app, TSHC guide, that also you may have. It will be very helpful in the field. And then about various tools related to papers. You must have a few documents with you whenever you are available to the clients. You must have wakalatnamas, empty wakalatnamas. Whenever you meet the client, they can sign, you can sign, and the case can be filed. And also you must have the welfare stamps, 100 rupees welfare stamps, so that you can attach it to the wakalatnama and file. Then you must have memo of appearance. Memo of appearance, the function of that is very similar to wakalatnama, but in that usually it is used in those cases in which the client is arrested or there are chances of arrest and the client personally cannot come to your office. So he may send a friend or a relative, they may come to your place and sign the memo of appearance. Then the wakalatnama and memo of appearance are used to transfer cases between one advocate to another. An NOC may be given and an NOC may be accepted, which can be done by both the wakalatnama and memo of appearance depending on the nature of the case. And then you must carry 317, the paper which gives exemption to the accused for not for exemption from being physically present on the date. So on the 317 paper, it will be written that I am not disputing my identity, but because of so and so reason, I am unable to personally present myself in the front of the court, and please do not take this as the disrespect of court. And then 317 memo of appearance, copy application. Copy application forms are available in the courts and also outside. Whenever you get a case, usually you would like to take out the documents which are there inside the court. So bring out those documents, you may have to apply for a copy application or certified documents. So if you have a CA form, you can just fill it up and give it to your advocate clerk. If you have a team or if you work alone, you yourself can go and give it in the CD filing section or copy application section or copying section, whatever you call it in that particular court, and give that paper and get the certified documents. And then accordingly, you can plan your counter. So this is the thing. 4 more minutes are there. If brother would like to add something, we could take. Okay, it's a bye from me.
Yes, friends, like Musab Hashmi sir said about the things we should have in our office. Like most of the people don't know about what is the copy application. The copy application is an application we made before the court to get an certified copy from the courtroom. Like if you want any certified copy, then we have to file an copy application. The process of filing an copy application is that we have to take a copy application which is in a specified format. We have to fill the format, and the person who can file and copy application is an advocate who is on record or the party in person. uh, Most of the time third party also file and copy application, but it should be approved by the honorable judge. Without the permission of the honorable judge, the third party cannot get the copies of the orders. If they get the copies of the order, it is illegal. And without the permission of the honorable court, the third party cannot made an application before the copy application authority. The petition should be filed before the judge for getting the copy application. And advocate on record is the person who is having an authority to file an copy application. And most of the time, this party in person, the clients also file an application before the uh, issuing authorities. So what is the use of the certified copy? Actually, the certified copy is the only copy which is accepted all over the government offices. We can use it for further references, like it contains the stamps and signatures of the honorable judges on it. So it is acceptable by all the authorities, government officials, and all. We can also use it as an evidence for further reference for the government authorities or people. If the stamp and signature is not on the copy application, it is called as an duplicate. Most of the time people will not trust on that copy. So if we are getting the certified copy, then people believe it is an authorized copy, and it is a genuine one. So we can get the copy application around 3 to 7 days, working days. I'm talking about the working days. So within 3 to 7 working days is the time to get a copy application. In few of the cases, we can get the copy application on same day. Like we have to take a carbon copy. Carbon copy is the copy which is issued by the stenographer as and when we apply for the copy in the most urgent cases. For other copies, we have to wait for 3 to 7 days, and we have to write down what all the things we required. I think time is moving very fast, and we are left with only 1 minute. I want all of you to be a part of the advocacy and become a
साइबर क्राइम नेक्स्ट सब्जेक्ट है.
in the next session, we will talk about the cyber crime. I wish all of you to best of luck for their future. Thanks. See you again. Bye bye.
Okay, friends. Thank you.